Thank you. We are here on a single matter that has been noticed up for argument. The case is designated by number 2019-0933 in regards to the adoption of B.F.S. We welcome you, Mr. Litchfield, and we recognize that we're doing this via video and pursuant to the Chief Justice's administrative order related to the COVID virus. And we appreciate you doing this somewhat different than we usually do. We hope that you'll find that you can make all the arguments you want here, just as you would before our court in normal circumstances. We would allay any concerns you might have, that if we have any technical difficulties that might have prejudice visited upon you. We assure you that if there are any technical difficulties, we'll work around them and be flexible to the extent that we can make sure we hear all of your arguments. This case is also remarkable in that, as we have just mentioned, there is no appellee in this case. There's nobody arguing against your appeal. We are also aware that there are two other appeals pending, and perhaps it'd be best just on the record for me to make a note of their case numbers. One is in the adoption of BN, which is 2019-0929. The other is in regards to the adoption of BP, case 2019-0934. We just wanted to let you know, Mr. Litchfield, that we are going to be considering all three of those appeals today. We just designated one for our oral argument. And given that there is no opposing side, we have no problem with you, if you need to, talking about the differences between the three of them if you wanted to address those. But do you have any questions before we proceed?
I don't think so. On two of those cases are virtually identical. One of them, the judge ruled slightly differently. And I just prepared for the one case, and so I'm not quite as up on the argument as I would have been.
Right.
But I'm sure I'll be fine. Yeah.
Yeah. Okay. Judge Appleby.
So before we get started, Mr. Litchfield, I wanted to ask you, what is the status of each of these adoptions at this point? Are these children in legal limbo right now?
Can I, Judge Appleby, you began that phrase with "before we get started," which I think has teased Lisa into not starting the clock.
Oh.
Okay, the clock is now started. You may answer the question if you remember it, Mr. Litchfield.
Your Honor, I believe that these adoptions have been finalized in other states. I'm not positive about that, and I didn't check before this hearing. But it's the kind of case. These are the kind of cases that, because of the nature of the case and unopposed, and these are almost transactional cases, and so I felt like I needed to appeal these. What we really needed on all three of these was to have an order so that we could get a copy of the birth certificate so they could finalize in these other states. Utah doesn't appear to need a birth certificate, but these other states wanted to have a birth certificate in the file, and nobody was able to get that. And so that's why these were filed.
But Mr. Litchfield, then how are these cases not moot?
Because they by the fact that there's three of them, we can see that this is the kind of thing that will come up again and again and again. And it fits that exception to the mootness doctrine. So, although this is my first appearance in an appellate court, I've handled probably about 600 adoption finalizations and 1,000 total adoption-related cases. So I know the area, even though I don't know I'm not as familiar with the format, and I've written briefs before. But I'm also happy to make that appearance on Constitution Day, celebrating one of the greatest inventions that humans have ever made. in these kinds of cases, and in many adoption cases, there's no opposing party, and that doesn't mean that it's not opposable, or that there are no other interested parties. That means that all the parties have agreed to, in one way or another, that the matter should go forward. In my practice, I've sometimes had judges who, because there's no opposing party to state an opposing opinion, they take the position that then they have to become sort of the opposing party. And so even though it's great to have to appear in front of the panel and have no appellee, the concern always is that as your honors think about the case and weigh the considerations, it's actually you that comes up with the counter arguments, and that's always a concern. But I'm sure with this panel that's going to be fine, and I know this each of you judges well, so I'm not too worried about that. One of the
Mr. Litchfield, may I inquire? It struck me right away that all of these cases, and another one or maybe more than one that you allude to in your brief, involve the exact same district court judge. I assume the system is not stacked so that all of your clients' petitions are automatically routed to him. Do I correctly infer that with all other judges in the state before whom you've brought similar petitions, there has not been the same kind of resistance offered by the judge as was offered here?
The reason they're all the same is because I filed them in Tooele, which was part of the 3rd district, and so I was using Tooele at the time as to file some of these routine matters. These are particular to Judge Bates, but I've had a lot of judges on these kinds of things require me to write a brief on summary on subject matter jurisdiction, and I've actually gotten kind of good at writing that brief because I've written it a number of times. And then it seems like there are a number of judges in the district court, probably in the 2nd, 3rd, and 4th districts in particular, who are trying to find a way not to handle cases involving a child who was born in one state, placed with a Utah agency, and then to be adopted by a family in a 3rd state. And that's another reason why I brought this, is because I'm seeing a more general trend toward this. And as I say, when they say, we don't know if we have subject matter jurisdiction, I say, oh, you assuredly do. And you're not supposed to bring up venue and personal jurisdiction. And then they proceed at that point generally.
Can I inquire a follow-up? Sorry, Judge Toomey or Judge Appleby, I started my sentence before I saw your hand. Given the fact that these cases that we don't have children in legal limbo, and I was very reassured to hear that as far as you're aware, the adoptions have moved forward and they're done. I take your argument that given the nature of these and the short time frames that we like to see happen in adoption cases, although technically moot, deciding one or more of these cases would be appropriate under the exception that you alluded to. Given that there is no great rush, and that there are apparently perceived interests of the state of Utah relative to facilitating an adoption between basically strangers to the state. I mean, you do make the point in your brief that your client is a corporate citizen of Utah and is proud of its national coverage, but insofar as there is a legitimate concern about a Utah agency and Utah courts being involved in facilitating the adoption of non-Utah babies conceived and born of non-Utah parents and placed with non-Utah adoptive parents, would there be any great opposition on your part to our taking a pause and perhaps inviting the Attorney General to weigh in on this, and give the Attorney General a chance to be heard if there is a perceived concern about Utah messing where it shouldn't be messing?
Judge, if you think that's a wise idea, then I think that's a wise idea. I don't have any problem with that. I'm not aware of any statute, case, or any other source of law that holds that it's not in the best interest of the child to have a determination of under the Utah Adoption Act if the child and family are in other states. And what I perceive is going on here, yes, Judge Morrison.
Could I just ask about that, because there are three things that Judge Bates looked at least to my view, in his rulings, and that was that whether the birth mother had consented, and in all of these cases he found that they had, or that the petition alleged that they had, and that was sufficient. There's a requirement the agency be willing to take custody of the child, and he didn't have a problem there. It seemed to be best interest, and in that, he said he had to look to 78B6-102 to determine the health, safety, and welfare of the child and the moral climate of the potential adoptive placement. So my first question is, in determining best interest under the determination of rights statute, do you think it is proper and required that a district court look to 78B6-102?
Your Honor, we have case law that says that it's in the best interest of the child is to follow the procedures outlined in the code in general. And in this particular case, we're not finalizing the adoption. And I'm open to the idea that a judge could see something in a case like this and say, "Oh my goodness, this is terrifying." But there's nothing like that in a case like this.
Yeah, that doesn't answer my question, to be honest. My exact question was whether, because clearly the statute requires, specific to this kind of petition, that that the court make a finding as to best interest. And I totally understand your position that generally it is in the best interest of a child whose mother has disclaimed all rights to it to have an adoption facilitated. That totally makes sense to me. I could totally understand why the legislature would want that to happen. On the other hand, the statute's not in a vacuum. This determination of rights is part of the Adoption Act, and sorry about that. The adoption, or the Adoption Act then has this 78B6-102 that talks about the health, safety, and welfare of the child and the moral climate of the potential adoptive placement. So my question was, are those synonymous, best interest in the determination of rights statute and 78B6-102?
Your Honor, 102 subsection 2 actually incorporates pursuant to the requirements of this chapter. And I think, and in this kind of a case where we're not finalizing the adoption, we're not deciding whether the placement is in the best interest of the child and whether it's ultimately now and forever going to be in the best interest of the child. Well, I think that what 102 requires in this case is a determination that it is to realize that the determination itself is in the best interest of the child.
Well, it seems to me that what Judge Bates was saying is I can't make a determination based upon your petition about the potential placement because I don't even know who the adoptive parents are. To me, that seems to be a disconnect in the determination of rights context, because we aren't actually talking about the placement of the child in the adoptive home necessarily. we are talking about the placement of the child with the agency, right?
Yes. And specifically whether the birth mother's rights are terminable, whether the birth father's rights are terminable, and whether the agents and the fact that, which is by operation of law, that the agency has custody and control of the child, which in this case is what we needed, was that part so that we could share that with vital records in Michigan.
Let me ask you kind of a go ahead, Judge Appleby.
It just gets back to my earlier question. Maybe you better follow up on what you're discussing right now so that we don't cause Mr. Litchfield to lose his train of thought.
Well, in connection with that, I have this question. The court, it appeared to me, was just looking at your petition, saying your petition doesn't contain sufficient information for me to make a best interest analysis, and therefore I'm dismissing the petition. I guess my question is, if a district court is truly concerned that insufficient information hasn't been given to the court, is dismissal the right course, or does the court say your petition, while having the tree branches, I need to see the leaves, so I'm denying your petition for now, I'm not dismissing it, I won't sign a final order, you have to give me further information, either by affidavit, for example, or an evidentiary hearing where you could bring evidence sufficient to satisfy the mind of the court. Do you think that's what should have happened, or are you just saying that absolutely this is a ministerial act, and by simply reciting the elements of the statute, the district court is discretionless in signing your order?
I think that the court can and should ask for information that it needs that is not provided in a case like this. There certainly can be a request for information. There can be a hearing. There can even be an evidentiary hearing if that's required under the circumstances. In this case, or in two of these cases, I went back and asked I filed a motion to reconsider of some kind, and asked them and pointed out to the judge, this is what's going on, and provided some extra information. He didn't ask for any particular item, but that did not persuade him. If
you don't mind, Judge Appleby, because let's tag on to his last thing. In two of the cases you did do that. You did a motion to alter or amend, which I'd like to commend you on, because such a motion actually exists, whereas a motion to reconsider doesn't. So that's great that you did the proper thing. However, in the one case, I guess we'll call it In Re BP, you didn't make that motion. And here's my question on that. When you made the motion to alter or amend in the two cases, the court did a memorandum decision explaining why it didn't want to do that, and it denied your motion. But in those cases also, the ruling says the petition to determine rights is therefore denied and the petition is dismissed. In the case of BP, the court says the petitioner's request to determine rights is therefore denied. I don't see, and I looked real quick, and luckily it was the shortest record of the three, I don't see an order dismissing the petition in Re BP. Does it exist?
I'm not aware of anything besides what you read, but I took denied as being the petition's over. That's the end of that case.
If we viewed that differently, that might not be a final order, and we might not have jurisdiction in that case. Do you recognize that?
I recognize that. I hadn't noticed that subtle difference between denied and dismissed and just denied.
Okay. Judge Appleby, I am done. Sorry about that.
It's all right. So I agree that with what Judge Mortensen said about motions to reconsider not being recognized in the rules of civil procedure. In fact, the Supreme Court has called those the cheap grass of litigation. So, appreciated. But what I wondered was whether, from a procedural standpoint, a Rule 65B petition might be a more appropriate means of getting Judge Bates to do what you're seeking to have Judge Bates do.
I'm not familiar with 65B. Let me look at it real quick. 65B.
It's a writ. So what Judge Appleby is asking you is, let's say, for example, we were to say, hey, all of these cases are moot because they've been finalized. In other words, if a district judge denies these and the adoption goes through in a sister state, they will perpetually be moot. I guess under that circumstance, and I'm just thinking off the top of my head there, if it consistently evades review, on the one hand, you might argue, well, then it's not moot under that branch of mootness. Or I guess you could argue, if it continually evades review, maybe you don't have a just, speedy, and otherwise available remedy other than a writ. I think that's what Judge Appleby might be getting at.
Thank you.
So what would your answer to that question be, Mr. Litchfield?
You know, I didn't really prepare for a mootness argument, but I think that I don't know that I just don't know that area of especially appellate jurisdiction. I know how important it is to file an appeal on time, and on these cases, it's because of the difficulty in appealing these kinds of cases, and the increase in trouble. I mean, I think one of the reasons I haven't been in front of an appellate court is because when a judge says no, the least expensive and easiest thing is to figure out another way to accomplish what you're trying to do. In these particular cases, his decision was final enough, and also he didn't really decide them on the merits of them as individual cases. He didn't say, you know, in this particular case, I'm seeing this problem. He said, it's never in the best interest of the child for a Utah court to make a determination, even when Utah law applies, when in this kind of a context where you have two other states involved and the connection is the agency. And so that's why, and I suppose I'm aware that you can file an extraordinary writ, but my perception is that that's, you know, you end up doing a ton of work right up front to get it in front of the court really fast, and that tends to be expensive and a bit chaotic. And on these, I said, look, we'll find another way to finalize them, but in the meantime, we really ought to appeal these and get a ruling that this kind of thing is not contrary to the best interest of the child, and in fact, it's specifically contemplated in the statute.
Well, and just to put your mind at ease, perhaps somewhat, we have a long-standing institutional bias against petitions for extraordinary writ and being put in the position basically of bossing a lower court or tribunal around. Our institutional preference is to prefer the appeal route. And many times over the course of the year, we will deny a petition for extraordinary relief for the specific reason that there would be a plain, speedy, and adequate remedy at law in the form of the appeal. Now, the one thing that I would have to say that makes the extraordinary writ avenue slightly more appealing here, and of course, it's awkward to invite counsel to do that because you end up suing Judge Bates.
Judge Bates would have counsel, and we would have the benefit of having somebody argue the opposing side.
That's what I was coming around to, is when we have those cases, we do have the district court judge typically represented by the court's general counsel. And so we will have the opportunity for someone on the other side. Occasionally that work will be farmed out to someone in the AG's office or even private counsel. But in the vast majority of those cases, that's part of the general counsel's work. So it's not as clear as it sometimes is, because we would have that added benefit of counsel representing the other point of view. But in the interest of fair and full disclosure, I'm on record many times over the course of a long stint in this job of being quite adverse to petitions for extraordinary writ, district court judges being sued, appellate courts bossing district court judges around outside of the context of an appeal. So I think it's a fair question. One will no doubt think about, but I would hate for you to go away thinking, oh, that's what I'm going to have to do going forward. That's not necessarily, it's not necessarily clear to me that that is a preferable option.
I see I'm out of time, and I'm happy to make some other points if anybody wants to hear them, but.
Dave, you're mute.
I am mute. Any other questions from any other members of the panel? I see no takers. Unless you have anything to add, Mr. Litchfield, that will conclude the oral argument. We'll take all three of these cases under advisement and issue written opinions or orders as may be appropriate. Thank you for your arguments today, and we appreciate you again being flexible to argue before us in this format. So have a good day.